Hello, good morning, good afternoon, or perhaps it's evening. My name is Herricia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because Grenada matters. Today's show, we're going to look at divorce and judicial separation. Someone specifically asked for an explanation of judicial separation.
Okay, so what we'll do, we've got some beautiful slides that you have previously done before, if I'm correct?
That is correct. Just this year, I was lecturing on family law. Right, divorce comes under the topic of family law. Family law is a very broad subject and deals with, as it says, the family. A brief background on divorce, because divorce is not or has not always been that accessible. The reason why is because in the mid-19th century, the law largely adopted the Christian view of marriage. That view is that marriage is an indissoluble, lifelong union. So, in the 19th century, when you were married for life. So, although nullity degrees could be made, that means Parliament would nullify the divorce. So divorce was not available through the courts. The church courts could grant a divorce, but this was more like a judicial separation than divorce. I will explain about judicial separation after my explanation of divorce. So the parties were free to live apart, but could not marry again. This apart, the only way of obtaining a divorce was by a private act of Parliament. This was very lengthy and expensive procedure which only a few individuals could afford. The very first act of this kind was promoted by the Duke of Norfolk in England way back in 1700. At that time, only 317 acts were passed nullifying a divorce in the following 150 years. Bit different from today. So basically, the first act to create an alternative to divorce by an act of Parliament was the Matrimonial Causes Act of 1857. I hasten to add the Matrimonial Causes Act is a UK Act of Parliament that applies in the Commonwealth. But in the Act of 1857, only husbands may petition for divorce. The reason for that, at that time, women were still the property of their husbands. So, a husband could rely on his wife's adultery for a divorce, but a wife could only rely on her husband's adultery in extreme cases. This was for unnatural offences, incest, bigamy, desertion, would you believe it? After that came the Matrimonial Causes Act of 1923. That act put the husband and wife in the same position. That is to say, simple adultery was a ground of divorce for both the husband and the wife. This ground was further extended in the Matrimonial Causes Act of 1937. So the grounds of adultery expanded to include cruelty, desertion, or incurable insanity. So before 1937, only grounds for divorce was adultery. After the Second World War, there was an increase in the number of divorces. So by the 1960s, there was an increase in acceptance of divorce, even for religious bodies. Before that, it wasn't really acceptable for divorce. So by the 1960s, there were growing calls for divorce to be made easier. Simply, just one sole ground for that marriage, which is the marriage had irretrievably broken down. So the grounds there by the 1960s was that the marriage irretrievably broken down. Then came the growing calls for divorce to be made easier. The arguments in favor of making it easier focused on couples whose marriage had failed and who were forced to form relationships out of marriage with new partners because they were unable to prove the grounds for divorce. This was of particular concern over the number of children being born to unmarried parents. So it was argued that liberalizing the divorce law would lead to a reduction in the number of children born outside marriage. So this is what they thought. So the divorce law was subsequently consolidated in the Matrimonial Causes Act of 1973. Under that act, the only grounds for divorce was under Section 1. And that is, of course, that the marriage had irretrievably broken down. So that was the only one cause. Under Section 3 of that Act, no petition for divorce can be presented to the court before the expiration of 1 year from the date of marriage. So under the new 1973 Act, which applies to the Commonwealth as well as the UK, of course the Commonwealth is the Caribbean, Canada, and so forth, Australia, the whole wider Commonwealth. So when you petition for divorce, you can base that petition on matters that occurred from the date of the marriage, but you cannot present the petition to the court until after the expiration of that 1 year. I've said previously, under Section 1, the sole ground for divorce is that the marriage has irretrievably broken down. And you must prove one of 5 grounds. These 5 grounds are reasons, are facts for the divorce. So when you present the petition, that is the document for the divorce. So the person who presents the document to the court is known as the petitioner. And that document will be served on the respondent, regardless of whether it's a man or a woman. The person who presents the document is the petitioner, and the person who receives the document is the respondent. So back to what you must prove: that the marriage has irretrievably broken down. The 5 reasons which are listed under the Act as 5 factors to prove divorce. The first one, A, the respondent committed adultery and the petitioner finds it intolerable to live with the respondent. So there's 2 things that must be proven here: that there has been an adultery, and the petitioner finds, because of that adultery, he or she finds it intolerable to live with the respondent. There are 3 things I must stress here. You cannot rely on your own adultery to prove that the marriage has broken down. It must be the respondent, the person who will receive the petition. That person must have committed the adultery. So it is not enough to show adultery. You must show, as I've stated before, that you find the respondent intolerable to live with. Of course, lawyers rely on other case law when they're putting matters before the court. So in a case called Cleary versus Cleary 1974, there it was established that it is not necessary to show that the reason why the petitioner cannot live with the respondent is due to the adultery. The significance of this case lies in the decision that the intolerability of living with the respondent need not relate to the adultery. So the petitioner can obtain a divorce if the respondent has committed adultery, regardless of whether the adultery was the cause of the marriage breaking down. Let's look at B, unreasonable behavior. This grounds is a very popular ground for individuals to rely on for divorce. Section 1(2)(b) of the Matrimonial Causes Act states the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. Here, it is not enough to prove that the respondent has engaged in unreasonable behavior. How it's decided, the behavior must be such that a right-thinking person would think the behavior was such that the petitioner cannot reasonably be expected to live with the respondent. So, under this heading, the court usually takes into account the personality of the parties when they're deciding on the conduct to see if the conduct is sufficient to prove this ground. So, if the petitioner is reacting unreasonably to the respondent's behavior, the petition will fail. Of course, domestic violence falls under this heading, but a wide range of conduct can be included under this heading. For example, homosexual activity would fall under this fact and not adultery. The third fact or reason for divorce is the respondent's desertion. Section 1(2)(c) specifically states the respondent has deserted the petitioner for a continuous period of at least 2 years before the petitioner petitions the court for divorce. So the respondent cannot rely on this ground if the petitioner cannot rely on this ground if the desertion is less than 2 years. The fourth one is the most popular factor. The reason why is because section 1(2)(d) is based on 2 years separation and the respondent consents. Please note, this ground, there's no fault. The other 3 grounds I've stated, you have to find fault in the other party to obtain a divorce. But under 2 years separation, the other party consents. So if the petitioner can establish that there's been 2 years separation before he or she presents the petition and the respondent consents, a divorce can be granted under this ground. It must be noted also, because this is quite common in the 21st century, because of living arrangements, you can be living apart but live in the same accommodation. You must show the court that you are living separate lives. For example, in a case Hollins versus Hollins, the husband and wife both lived in a house but did not speak, eat, or sleep together. The court held they were living apart. So living apart, this need not be a mutual wish, nor need it be communicated. So if the husband, say, is in prison and they've lived apart separately for 2 years, the other can rely on this ground. The fifth and final reason to prove the divorce is 5 years separation. Most opponents call this section 1(2)(e), as the Casanova Carter. Here, the petitioner can rely on the fact that the parties have been separated for 5 years before the petitioner presents the petition. This ground here, you do not need the respondent's consent. All 5 grounds, if you've lived apart and then you return for 6 months or less, that time frame will not be included. However, if the parties reconciliate for 6 months or more, this time frame will be counted. So the time starts again. Right, let's look at the defences to the petition. Section 5 of the Matrimonial Causes Act provides a defence. This is for the respondent who does not wish the divorce to go through. The defence is available if the divorce would result in grave financial or other hardship to the respondent, and it would be wrong in all the circumstances to dissolve the marriage. This defence is not widely used in the 21st century. Usually, and the reason for this is because in the UK, the courts could split or divide the other spouse's pension. In certain circumstances where, for example, the petitioner is the male, and the wife has lived at home, raised the children, looked after the home, and has not received a pension of her own, she could rely on this defence. But as I say, in the 21st century, where in the UK you have pension splitting, where the courts could allocate a certain proportion of the respondent's pension to the petitioner. So that is divorce. I've just taken you through the grounds for the divorce, which is just one ground, that the marriage has irretrievably broken down. But there are 5 facts, reasons to prove that the marriage has broken down. Now let's look at the little known judicial separation. What is judicial separation? Well, it is a decree, a court order similar to a divorce. But where a judicial separation is in force, the parties still remain legally married, but their normal marital obligations cease. So there's no time limit in place. You can just apply for judicial separation even if you've been married for less than 1 year. You don't need to prove that the marriage has irretrievably broken down. But you do need to say what grounds you are relying on. A, B, C, D, or E. I've gone through that previously. The process involves getting just one decree from the court. That is a decree of judicial separation. Once this is issued, you can legally not live together and not be regarded as seen as a couple, but you are still married. The difference between a divorce and judicial separation: divorce ends the marriage, judicial separation does not. Judicial separation is quite unusual and is usually relied for religious reasons, where religion would forbid or where divorce is frowned on and for religious reasons. So the main difference between a judicial separation and divorce: one, a divorce legally ends a marriage, but a judicial separation does not. Two, you can marry other people after getting a divorce, but not after a judicial separation. Three, you have to prove that your marriage has irretrievably broken down to get a divorce, but you do not need to prove that with a judicial separation. Only show the reasons, the facts for the divorce. Four, you can get a judicial separation at any point, but with a divorce, you must wait until you've been married at least 1 year. And finally, the court cannot exercise its power to divide a pension pot with a judicial separation, but it can do for divorce.
Okay, so why would somebody apply for a judicial separation?
Well, as I've said, for instance, some Catholic countries would forbid divorce. That way, you would get a judicial separation. You're still married, but all the formalities of marriage falls away. You do not need to live together. You're not relying on the other partner.
Can you apply for a judicial separation? Like if it's a domestic violence situation and you need an emergency hearing, can you apply for the judicial separation and then apply for the divorce afterwards?
I've never known that to happen,
Okay.
but it can happen because it's your views why you go for judicial separation.
You think you can heal things? You can heal things between you and your partner. They may have an alcoholic problem. You know, they may have been going through stress at a time, so they don't want a divorce, but they need to separate.
That is correct. But usually it is used for religious or cultural beliefs that don't recognize divorce.
Right.
But it
I
can be
understand.
used for that. Yes.
Okay.
I know at one time it was used quite often in Ireland. That is
Yes.
the only reason why I mentioned the Catholic on that basis, because I'm
Yes.
aware of in Ireland, and I'm sure you have as well.
Yes. Yes. The people being stuck in marriages, unhappy marriages, for the sake of it.
They usually do it for reasons other than for the sake of it.
Right. Right. Is there any time the judge will reject a divorce, or does the court have any reasons to reject a divorce?
Not in this 21st century. At one time, yes, maybe, but parties there's usually when in a divorce situation, say like 40, 50 years ago,
Yes.
one partner would not be working and would be relying totally on another.
Yep.
But now the nuclear family, the man and the woman is working. They can live an independent life of each other.
You do see in the celebrity world, people getting married and then getting divorced 45 days, 30 days. How does that work in this system or this situation?
Not
Is it the
under
same?
the not under the Matrimonial Causes Act.
So how are they getting these divorces then?
It's different laws, and that's usually in the state. In
Yes.
America, different laws, right? Under the Commonwealth law, if you get married today and tomorrow you find it's a mistake, you have to wait 1 year from the date of your marriage to obtain a
Wow.
divorce.
Wow.
But you can rely on anything that happened within that 1 year.
So what happens if within that 1 year, a domestic violence, adultery, do you have to stay with that person for that year, even though you've
No,
experienced that?
no, Ingram.
Okay.
You don't need to stay with that person from day one, but you cannot obtain a divorce for 1 year. It does not compel you to live in that intolerable situation. All it says, you cannot file for divorce, petition for divorce in the first year of marriage.
So your life has to be on a standstill for a year, even though you separate from that person. Your life is on a standstill for that year because somebody else has acted irresponsibly.
Why is it one person? It takes two to tango.
Yeah, but if one's gone and committed adultery, or if one person's to be the person that's caused the domestic violence, for example, these because these are popular or these are regular events that you hear about within the Caribbean or around the world for that matter. So for that year, let's say I'm in that situation and I might have dealt with domestic violence, or the woman may have been, might have been violent with me. She may drink a lot, or she just may have a bit of a temper. Didn't realize that until I got married to her. Got married to her, and then I've like deal with it.
Your life
Vice
does not.
versa.
Your life does not have to stop for that year. You just cannot petition for divorce.
But I'm still
You
married.
can rely on all
But
that fact.
I'm yeah. But I'm still in the eyes of
You're
the law
married
married.
in the eyes of the law, yes. In the eyes of the law, you're still
Yes.
married, but, but
So
it
if
doesn't
I
say you're
so if
bound.
I say if I yeah, but if I decide to move on with my life, or she decides to move on with her life, they can't really because they're still considered married and they can't progress with their life, can they? Or can they?
You can still progress with your life, but you just cannot get married or divorced for the first year.
Right.
When you say move on with your life, you mean marry somebody else?
Well, you get to you continue, can't have another relationship, for example. You're still considered, in that case, you're still deemed in a marriage. So if you decide to go out now and have a relationship with somebody else, then you'd be committing adultery because you're having a relationship with somebody else outside of your marriage. You're still considered married, right?
Yes, you are, but
So then,
I don't think in this 21st century that rule is hard and fast. Yes, you're still divorced, but you be relying on anything that occurred within that first year. You just do not have the piece of paper to say you're divorced. What is the obligation for that first year?
well, they say there's some people say because of their uh, religious beliefs or believe that married till death do us part. That's stuck in a person's mind. They get in a situation 3-4 months into the marriage, it's not working out, and then they feel afterwards guilty and they can't move on with their life because they still feel they're married to that individual, even though that individual's consistently gone and done stuff that's not abusive. So you hear people going back to people because of abusive relationships. Do you understand? They keep going
But
back to them.
lowering the time to get a divorce will not stop that person going backwards and forwards. But what it does, it gives them time to think. Is this what I'm doing, what I want? Because did they think before they stepped into the marriage? It's the same sort of situation. It's a cooling off period. It's a serious commitment. So it's to preserve the sanctity of marriage.
Okay, but in the states they have it for 30 days. Like
That is
you get
that
there
is
you
the
go.
that is the state.
I know, but I'm saying, I mean, you're talking about the 21st century. Why is it not that we're not all in kind of unity with this idea? Well, it has to be a year. Why is it not just 30 days now? Would that not alleviate a lot more problems?
I don't really see what problems there's causing. What you're talking about, synchronizing laws around the world, that's not always possible. The Matrimonial Causes Act is 1973. We're now in it's 2020,
Right.
and many attempts have been made to rewrite the Matrimonial Causes Act. In the UK, they had the Family Law Act that was of 1996. Many of clauses have been abolished or appealed, and they've still gone back to the Matrimonial Causes Act, all around the Commonwealth. So, so far, it's been set in stone, an excellent act for individuals to regulate their life.
Okay.
Reducing the 1 year to 30 days, you have to preserve the sanctity of marriage, England.
So okay, move it to 6 months.
Why not leave it 1 year?
Why keep it to a year?
It
Why
may,
even why even get married at all in that case? Because I'm just I call it devil's advocate if you want, but I'm just saying that it's there. But if you unfortunately get yourself into a situation with somebody that you don't fit with, and it's a bit of a disaster, you're stuck with that tag of being married for a whole year. It also is a deterrent to those people, I would say, that think that they can just get married and do what they want. They can be because of for financial gains and stuff like that. They can be cut off from that as well. Not everyone's on the up and up with marriage.
no, but marriage is a serious commitment.
Well,
It's not
if it was,
something that you just take lightly.
I
It's, it,
agree.
it's to prove, it's to preserve the sanctity of marriage. So why reduce it to a 6 months thing? A year is more appropriate. It gives
Okay.
if you it's that's why these reasons for these pods to educate people. If everybody knew, because everyone's got a choice. Common law relationships, living together, is on the increase worldwide. There have to be a divide. You have acts of parliament, statutes for civil partnerships. You have rules for cohabitating. So you also have rules for marriage.
So if you were to increase the year to make it 2 years before you could get a divorce, then would that be a deterrent to people who didn't take marriage seriously? If we're going to talk about the sanctity of marriage.
Well, 2 years is a bit long time. 1 year seems to be in the middle ground. Why would you want to raise the bar so high?
Because
You
that
want
way,
you
but
don't
that
want to deter, you want to preserve.
yeah, you want to preserve, but that people would be more serious entering marriage in the first place. So they're like, yeah, well, I can get over the year. 2 years is like, no, I got to seriously look at you because I got to seriously court you to make sure that when I get married to you, that we're going to work this out. A year is like, yeah.
Well, most people they get married because they love each other. So they don't
Mm,
think about the 2 year thing
but I
unless
would.
unless it's an economic sanction.
Right, but then I would argue you and say to you that the rate of divorce is going up in the world, not going down.
Seriously going up, going down, up.
So
Yes.
there's my argument for that now. You see,
But
that's statistics.
marriage is still staying. It's still on the increase in a lot of countries.
Yeah, but how long they're lasting is the question.
People are getting married much older now, and the older marriages are lasting very long.
Yeah.
Apart.
Interesting.
Maybe like some countries like Grenada, the age of marriage is a certain age.
Yeah, maybe they can increase. I don't know. Maybe they can increase the years of when a person should get married.
Thank you.
Okay, so
Rather than the length of time before you can get a divorce.
interesting. Discussions.
Yes.
Yes. Miss Willis, as always, thank you so much.
Thank you very much, Ingram.